Hello, and welcome to this webinar from Synergy Settlement Services. Today we'll be covering compliance with the Medicare Secondary Payer Act and what to do if your client also has other public benefits. My name is Evelynn Passino, and I am an MSP Compliance Attorney here at Synergy. I am licensed in Florida, and I specialized in elder law in law school, which gave me a great foundation for handling these public benefits issues. Prior to my career in law, I was in the Medicare Advantage space for the better part of a decade, and more recently, I had the privilege of leading a nonprofit that administers pooled trusts for injury victims. So these kinds of trusts included special needs trusts, settlement preservation trusts, which is how I built a lot of my knowledge around these public benefits issues. Now, before we get into the meat of the presentation, if you've never worked with Synergy before, this is what we do. We help plaintiffs' firms with the case after the case, and we do this by having experts in each of these areas standing by to help your clients maximize and protect their settlement. So if we can help you in any of these areas, please give us a call. So this is what we'll be covering today. I'm going to start with an overview of public benefits and some basic preservation strategies. That'll just help us kind of get a lay of the land for all of the different benefits that we could be talking about. And then we'll move on to more of a deep dive on the Medicare Secondary Payer Act and what you can do to comply with this act and make sure that both your firm and your client are putting themselves in the best position. So here I have a chart showing some of the common benefits that you might encounter with your clients. I have them organized according to the type of benefit in terms of how a person qualifies for it and how they secure it, and then also by whether the benefit is a cash benefit, which you can think of as getting a check or getting a direct deposit every month, and which of the benefits are medical insurance. So the means tested benefits are the ones that are income or asset sensitive. You may have also heard this called needs-based benefits, but these are the benefits that part of the qualification, in addition to having some kind of a disability, typically, it also has a financial component as well. And so in that case, if someone has too much money in their bank account or they have too many assets, then they're going to lose that benefit. So SSI being the more common one. I did include here that currently the SSI payment can go up to $841 per month for an individual. This can be helpful because if your client doesn't know exactly what benefit they have, then finding out how much their check is every month might help you pin it down. I'd say maybe it's better to get a copy of the award letter if you can, which can be obtained online from the Social Security Administration's website. But knowing that the amount that they're getting can help you determine, because if it's more than $841 per month, then most likely it is Social Security disability and not SSI. However, there are some states that supplement the SSI payment, so again, this is not a for sure way to tell, but certainly can help you on your way. Another thing to look at is what other types of benefits a person has. So if they also have SNAP benefits, Section 8 housing, or Medicaid, then those also being the means tested benefits, if they qualified for those, they probably qualify for SSI also. And I do have Medicaid highlighted here because it often goes hand in hand with SSI. And that's because in a lot of states, one of the ways that a person can qualify for Medicaid is by getting at least $1 in SSI coverage for the month. And so if you've got a client who's got Medicaid and they have a Social Security benefit, it's probably going to be SSI. And then moving on to the entitlement benefits, these are the benefits that once a person is qualified for them, typically they are secured at that point. There is no financial component to this. They could have $1 million in their bank account and it's not going to cause a problem for these benefits. But often SSDI benefits go hand in hand with Medicare, whether that's original Medicare or Medicare Advantage. And that's because in order to qualify for Medicare, one of the ways that a person can qualify is by having SSDI benefits for 24 months. So if you've got a client who is under the age of 65 and they've got a little bit of a working history, they're getting more than $841 a month, then most likely they've probably got SSI and they're going to qualify for Medicare at some point as well. But again, it's always better to verify rather than just going based on what your client's telling you, because we do see clients who get confused about this all the time. Even see some attorneys who get confused about what they are, because they are all called very similar things, so it's easy to understand how they can get mixed up. But always good to get a copy of that award letter if you can, or get copies of their benefit cards. And then just one last caveat is that there are a lot of different Medicaid programs out there. Certainly they vary by state to state, but also they can vary within the state as well. So you may see programs that are income sensitive, some that are asset sensitive, some that are neither, some that are both. And so again, that's why it's important to always verify what the benefits are and what the specific qualifications are that the client needs to meet in order to keep them. So if you're helping your client work through what to do with the money they get from their settlement or from their judgment, the question that's going to come up is, whether or not the things that they want to do are going to be countable, or whether or not the assets they have now are countable. So generally, anything is countable unless it has a rule that tells you it's not countable. So you can kind of start with that as a beginning point. Also important to keep in mind that just because you haven't given the person the money doesn't mean that it's not countable to them yet. Sometimes attorneys will think that as long as they keep the money in their trust account, it basically remains shielded from Medicaid or SSI finding out about it. But the way the rules actually read is that once that money is available for the person, or even set aside for them, that at that point it does become a countable resource potentially. So it's important to get started on doing this kind of planning, public benefits type planning for a person pretty early on, to make sure that as soon as that check is ready to go out to them, that there's a plan for that money, whether it's going into a trust or whether it's getting spent or whatever is going to happen. You don't want to hang on to that money for too long once you get to the point where liens have been paid and fees have been taken and all that has happened. You also want to keep an eye out for deeming, which is where the program might count the money that someone else has against the person who has the benefits. So this can happen from spouse to spouse, meaning if you've got you've got an injury victim and then, their spouse maybe also has a loss of consortium claim. You can do all the planning in the world for that client to make sure that their money is protected. But if that spouse is also getting money out of the settlement, then that is going to be countable to that client as well. So it's just an important thing to keep an eye out for, again, in terms of planning for the future and even in terms of looking at what kind of claims can be made in the case ultimately. So I talked a little bit about how, things are countable unless they're not. So the common exempt assets that you're going to find are the person's home, the home that they live in, and any personal items that are inside the home or maybe, very close to the home, in one vehicle. And there are some states that have some variance on this. Some states that allow 2 vehicles. There also can be some limitations in terms of how much the home's value can be. So all of those things are important to look at on a state-specific level. But typically the person's home and vehicle are not going to be countable, which is good because those are typically the largest resources that a lot of people have. But the things that definitely are going to be countable, the cash they have on hand, anything that's in their bank accounts. So certainly if you write them a check and they cash that, then it's going to be a countable resource to them. If they have any investments or they have items that they're holding for their value. So one way that you can think about this is by looking at a piece of jewelry, because that really can go either way. If it's a piece of jewelry that they wear, then that's considered more of a personal item or a personal piece of property. But if it's a piece of jewelry that they are just keeping in a safe because they know it's going to be worth a lot of money one day, and sometimes people do this with watches, then that probably is going to be a countable resource. So it's important to know kind of the characteristics as well. But if they're telling you, I'm going to take all this money and I'm going to buy, a bunch of gold bars with it, that's going to be a countable resource for sure. Like I mentioned earlier, money that's in the trust account can be a resource. And then anything that they give away also is a resource. So just because they don't necessarily want to hang on to the money themselves, maybe they want to give it to a family member or even put it in a trust for a family member. Medicaid and Social Security are going to look at that and they're going to say, well, you had this money, you gave it away, so we're not going to let you keep your benefits. So it's important too that if that is something the person wants to do, that they get the proper counseling on it first, because there may be some options for them there, but they need to talk to an elder law or special needs type attorney who can walk them through what they can do. So here we have a few different strategies for ways to preserve these types of benefits. So the overall goal is going to be turning a countable resource into an exempt resource or a non-countable resource. And so there are a few different ways you can do that. One is to spend the money. So, if the person doesn't already have a car or a home, or maybe they need to make improvements to those things, maybe they need to add a handicap ramp outside the house or a wheelchair ramp. They need to buy appliances or something like that. A lot of times people have accumulated a lot of debt during the case. All of those things are good ways to spend the money. But typically, depending on the program, typically there are going to be some requirements as far as how to report that. So again, that's an area where you might want to talk to an elder law or special needs attorney who is going to understand what that program requires to make sure that when that program ultimately wants to know what happened to this money, the person has their receipts or they have records that they can show to say, here's how I spent it. And hopefully that program will agree that those things were exempt resources. Another thing the person can do is set up an ABLE account. There are a lot of limitations on this one, so it's not the best option for everyone. The main one being that a person has to have been disabled prior to age 26. So unfortunately, injuries can happen at any age. We have a lot of clients who just are not able to take advantage of this, unfortunately. And the other limit is that they can only add $16,000 per year to that account. So if a person, if they're getting more than that as their net, then there aren't a ton of options. Although they could do a little bit of both of these things, right? They could put some money in their ABLE account for the future. They could spend some of it. They might put some of it in the trust, which we're going to talk about next. But there are some different things that they can do, and that's a limit per year, whether they spend it or not. So they can also put money in next year also. They don't necessarily have to just put $16,000 and leave it there. So there are some different options there. And then with a special needs trust, that's kind of the main option that a lot of people go for if they are trying to preserve the money that they have. Maybe they don't have a specific need for it yet. Maybe it's a person who's going to have needs that go on for many years. And rather than spend all that money down right now, they want to be able to have it available for their care in the future. And the money that goes into a special needs trust can be used for a lot of different things. The main rule on these is that it is a sole benefit trust, meaning that once the money goes into the trust, it can only be spent on the person for things that they need. So unfortunately, you can't, they can't gift money once it's in a special needs trust. They can't, go buy things for other people. It does have to be for them. But it does really come in handy when someone's got a lot of different needs that they have. They might be looking at some different therapies that are available that maybe aren't covered by Medicaid or Medicare. They can use money to travel. They can use money to buy a house. I mean, there's, really the sky's the limit with the different things that they can do. But it is important to understand that these are irrevocable trusts. So once a person sets up a special needs trust, it's pretty much set at that point. The only way to undo it is to go through a court. And if a court does approve dissolving that trust, then they also are going to require that Medicaid gets paid back if the person had Medicaid. So that often is a barrier to people. If they've got a pretty high Medicaid lien, then they might not want to go forward with that. Now we're going to move on to talking about Medicare and the Medicare Secondary Payer Act. So as I said a few minutes ago, Medicare is an entitlement benefit. which means that it doesn't matter how much money the person has in their bank account, they're not going to lose this benefit like they would Medicaid or SSI. However, that doesn't mean that there is nothing that they need to do or that the firm needs to do in order to make sure that they're complying with Medicare's regulations. So the big idea here is that Medicare doesn't want to pay for something that someone else should have to pay for. So what the law says is that Medicare will be a secondary payer when payment has been made or can reasonably be expected to be made in a work comp case, liability case, or no-fault case. And so the first way that Medicare addresses this is by issuing conditional payments. And so the idea here is that when medical claims resulting from the accident or the injury are passed through to Medicare, Medicare wants to make sure that they flag those and issue them as conditional payments so that when the case ultimately resolves, that they are able to seek reimbursement of those cases, or of those claims rather. And again, they're doing this because the way they see it, there is a different party that should be responsible for this. And once all that is sorted out, they just want to make sure that they're not the ones left holding the bag. So the obligation to repay Medicare begins whenever there is a judgment, a payment conditioned upon the recipient's compromise, waiver, or release, or by some other means. And by other means are defined as a settlement, award, or a contractual obligation. And so the way that Medicare finds out that this judgment or settlement has occurred is through mandatory insurer reporting. And that mandatory insurer reporting is basically the defendant's obligation to report to Medicare that the case is resolved, what all the details were of the settlement, the ICD-10 codes that apply to the person's injury, and all of those kinds of things. So that triggers, for Medicare to start looking for reimbursement of those conditional payments. And then it also allows them to mark up the person's file so that they are aware when claims come in the future, whether or not those are related to the person's injury. And so that has to do with, more of the forward-looking piece of this, which we will talk about in just a moment. But before we move on to futures, I want to talk for a minute about what happens if Medicare is not paid back. So it is really important to work on these conditional payments, make sure that they are addressed, because CMS has a right of action against all the parties you see here. So basically anyone who's been involved in the case who got money or moved money, right from the defendant, the plaintiff, the attorney, the doctors, they basically are going to go after everybody to try to get their money back. And so not only does Medicare have this private cause of action, but they also can seek double damages. So again, it's a pretty big deal to make sure that these are addressed. Certainly you don't want to ignore them and then have Medicare come back later and want to pursue double damages. And it's also important to know that this also extends to Medicare Advantage plans. So, just because your client is on, a United plan or a Blue Cross Blue Shield plan, if they're qualifying for that through Medicare, then ultimately that Medicare Advantage plan is going to have exactly the same rights as Medicare to seek the repayment of these conditional payments as well. So after conditional payments are addressed, you want to look at whether or not there are any future medicals to consider. Because again, Medicare takes the position that because the person got some money from their settlement, some of it's, probably earmarked for future medical costs, then they want to make sure that the Medicare beneficiary uses that money first before they try to pass those claims off to Medicare. So obviously the first thing you want to look for is whether or not this person is a Medicare beneficiary now, or whether they have a reasonable likelihood of becoming a Medicare beneficiary within 30 months of the settlement. So one of the ways that you can figure this out is by looking at the person's other public benefits. So if they have SSDI, or if maybe they've been denied SSDI, but they're going to reapply, then you can make an assumption that they are probably going to be Medicare entitled within the next 30 months. Because as we know, one of the ways to qualify for Medicare is to have SSDI benefits for 24 months. So that's kind of the first way that you're going to figure out which of your clients you need to address MSP issues for and which you don't. You're also going to look at whether or not the injury requires any kind of lifetime care or ongoing care. So, in some cases, the person maybe everything's kind of wrapped up at this point. Maybe they don't need surgery. Maybe they don't have any kind of ongoing needs, and if that's the case, then there really aren't any future medicals to look at. There's nothing really to plan for if there's nothing there. So that's also an important thing to understand. Doctors can be really helpful in this case, because if the doctor is able to certify that the person does not need any future care, then that's a situation where you could advise a person that they don't need to set up an MSA because, at this point in time, at least, it appears that no future care is going to be needed. You also want to look at whether or not the settlement actually funds future medicals. So, we see some cases where just because of the situation, with the way things shake out, there just really isn't any money left over for this. Once conditional payments are paid back, once attorney fees are paid, maybe there just isn't really a whole lot left. And so that's another situation where, maybe an MSA or something would not be advisable in that case. And then lastly, ultimately this is going to be about what is the plaintiff's risk tolerance and what is the firm's risk tolerance. So the firm's risk tolerance has more to do with the conditional payment side, but when you're counseling a plaintiff on whether or not they are going to set aside any money for the future, maybe they look at all this and they say, that's not for me. I'm gonna roll the dice. I don't think Medicare's ever gonna catch this, and that's okay. That's if they, after being advised of that, they want to go that direction. That's up to them. But the important thing is that they are advised properly and that they understand what the consequences are if they decide to make that decision. And lastly, we're going to talk a little bit more about how to comply with the MSP Act. So the most important piece of advice I can give you here is to have a plan. Have a methodical way of addressing Medicare compliance issues, whether that's a program you have in-house, whether you're working with experts, or, companies like Synergy, however you're going to do it, just make sure that you understand what all these moving parts are, how to address them, and how to identify which of your clients ultimately this applies to. So the best way to do that is to start early. This really does start at intake. At intake, you can look at who's Medicare eligible now. Maybe you have a client comes in the door who has SSDI, maybe they tell you they're reapplying for SSDI, or maybe you just identify that because it's someone who's got a long work history, they are now disabled, and so, a Social Security disability is going to be in their best interest ultimately. So those are all situations where, you would want to kind of flag the file to make sure that MSP compliance is handled. So the way that we recommend addressing this at Synergy is by starting with a Medicare Expert Case Evaluation, otherwise known as a MECE. And this is basically a call that occurs between one of our Medicare experts and you as the attorney and the client if they want to join, or maybe they've got, a friend or a family member who wants to join as well, just to make sure that they're asking all the questions they need to ask. That client might also have additional information or maybe able to clarify something about the treatment they've received thus far or what their future treatment is expected to be. But in any case, it's a really good opportunity for them to get all the information, really understand what the situation is, and then they can make a decision ultimately as far as how they want to handle things from there. So, the outcomes of this Medicare compliance consultation are going to be either a no MSA letter, and so this could occur for a few different reasons. This is basically where, either we're recommending that the person doesn't need an MSA, and that could be because the settlement doesn't fund future medicals. It could be because no further treatment is expected. But this also provides a legal basis for our conclusions and ultimately what our recommendations are. We can also provide an MSA analysis letter. So this is very similar in that it does provide that legal basis, but ultimately makes a recommendation as to whether or not the person needs an MSA. And then lastly, if the person, they've heard all of this, but they still don't want to do an MSA, maybe we've recommended an MSA and they say, I don't care, I want to roll the dice, then we can provide an MSA waiver that you can have them sign. And then, that helps you document your files so that, if they ever come back to you and say, hey, Medicare's coming after me or Medicare's denying my claims, you can say, well, we did counsel you on this, you decided not to do it, sorry. But ultimately, it makes sure that, whatever happens, that everything is documented and that you have a legal basis for whatever your conclusion is. So if your client finds themselves in a position where they are on Medicare or will be on Medicare in the future, and they are still treating and they do have some future treatments planned, maybe there's surgeries that they're going to need, durable medical equipment that they're using, prescriptions that they're going to be on for the rest of their life, and there is going to be money available from the settlement to pay for those things, then it does make sense for the client to evaluate whether or not a Medicare set-aside makes sense in their case. It's important to know this is never required. MSAs are not required by the Medicare Secondary Payer Act. However, CMS has said that this is their preferred method for a person to plan for future medical costs. So there could be consequences for not doing one. And the consequences are that if Medicare is getting claims for injury-related services in the future, and they are aware through the mandatory insurer reporting that this person got a settlement, and if there was money available, then they ultimately are going to deny those claims. And so, the client certainly doesn't want to find themselves in a position where they were expecting that Medicare was going to pay for surgery, they really need that surgery, but they've spent all the money from their settlement already, and now Medicare's denying that claim. That's not a good position for anyone to want to find themselves in. So that's why it does make sense for the person to really evaluate their circumstances to determine whether there's an alternative that works for them or whether an MSA ultimately is going to be the right fit. So CMS does provide a voluntary review process for MSAs. This does only apply to work comp cases, does not apply to liability cases, at least not as of July 2022. But basically, this is a process where if a case meets a certain threshold, so there are some monetary thresholds for people on Medicare, and then there's a different threshold for people who will be on Medicare in the future. If it does meet that threshold and it is a work comp case, then CMS can review it. And again, it's a voluntary process, so they don't have to do that. But basically, CMS reviews it and they'll say whether or not they agree with the amount that's been allocated. And so, the benefit out of this is that it does allow the person to come to an agreement with CMS or, a meeting of the minds as to what was appropriate and basically locks in the amount. So CMS can never come back and say, hey, that wasn't enough. So, that is, again, something that should be considered on a case-by-case basis. Also, I want to point out these review thresholds should not be confused with thresholds of whether or not to do an MSA. So there is no threshold of whether or not to do MSA because an MSA is not required ultimately. But sometimes people will look at the review thresholds or the thresholds to review and they'll say, well, my settlement isn't that amount, therefore I shouldn't have to do an MSA. And just want to be clear that, that's the threshold for the review process only. It is not a threshold for whether or not someone should do an MSA. Again, it's going to be based on the facts and circumstances as to whether or not they should do it. It is important that if a person is going to fund an MSA, that they do it right and that they spend it on the right things and that they are only paying for injury-related care that would otherwise be Medicare covered. And so, that can be kind of a tall order, especially because they need to keep track of receipts and bills and claims. And, there may be annual reporting that's required in some cases. And sometimes people don't want to deal with that. Sometimes people are not capable of dealing with that. And so if a person's going to do an MSA, they also want to figure out how they're going to administer it. And so they can administer it themselves. Again, they would keep track of all of that themselves, pay all those bills out of that Medicare Set-Aside account if they want to do that. But another option is to use professional administration, which is where a company handles all of this for you. So, basically whatever money should be set aside according to the allocation ultimately goes to this company. Usually they provide the person with a card, kind of like an insurance card, that then they show at their doctor's office whenever they're getting any kind of Medicare covered injury-related care. And then the bill goes to that professional administration company, gets paid, the person doesn't have to deal with it. So really all they have to do is kind of be aware of, are they getting care related to their injury or are they not? And so that's a really good option for some people. Obviously there's cost associated with that, but it just depends on what the person's skill level is and comfort level is with doing all that stuff themselves. If an MSA is funded, they also need to think about how they're going to fund it. So they can fund it with a lump sum. They can just throw all the money in there now, or they can set up a structure. It is required that a lump sum do go in, a smaller lump sum rather, go in to fund it initially, but then that structure can kick in within a year. This is another situation where it just depends on the facts and circumstances as to whether or not it makes sense to do a lump sum. In my experience, it's usually the smaller cases that do a lump sum because the structure just isn't appropriate, and the larger cases, usually they'll do the structure. One of the benefits of doing the structure is that if at any point the MSA is exhausted, so if it gets to zero, Medicare will resume coverage of injury-related care. So if a person is going to be really actively treating, then they fund that with the structure. There is a chance that every year they're going to spend all that money, and then Medicare is going to be on the hook for a little while until the next structure payment comes in. So just another thing to consider. And then lastly, these Medicare Set-Aside accounts typically are going to be just a bank account. So if the person is handling it themselves, then that money is going to go into a separate bank account that they set up and they control. If they're using professional administration, then that professional administration company is setting up a custodial account that they manage. But then there's another option for that, which is putting the money into a trust. And so this is going to be the most important depending on what benefits the person has. So if they do have those means-tested benefits like SSI or Medicaid, then if they're going to do an MSA, then it is very important that they put that money into a special needs trust. And so, this is kind of a whole separate area of the special needs trust industry where an MSA goes into a special needs trust. And that just makes sure, again, that it does not become a countable resource. Because if a person on Medicaid sets up an MSA bank account for themselves, that's going to be a countable resource. It can also be a countable resource even if that's done through a professional administration company. So again, it's really important if they have those benefits that they make sure that this MSA is set up properly. There are also some other situations where a trust can make sense for a person, even if they don't have Medicaid or SSI. If a person just has a very large MSA that's being recommended, and it's one that, maybe they're kind of young and this MSA is going to last for decades, then there is some additional protection that you get with a trust that might be, might be a good idea for the person. Again, just depends on what they want ultimately. Some people are very risk averse and want to make sure that they are, cover all of their bases are completely covered. And then some people are willing to take a little more risk with it. So, again, just really depends on what the person's circumstances are and what they want. And these are some of the alternatives that are available to an MSA. It is important to remember, one, that record keeping is critical. So whatever the person is doing, they need to know that they may have to account back to Medicare at some point, because this doesn't take away the requirement that they have to take Medicare's futures interest into account. So that requirement remains the same, whether they do that through an MSA, whether they do that through some other means. If in the future Medicare does deny a claim, they're going to want to see the records showing that this money was spent on injury-related Medicare covered services. And they're going to look to the total amount of future medicals that were allocated in the settlement. So that can be kind of a big number. One way to limit that is to get an MSA done. So, or rather an MSA allocation. So that's just the report. So whether or not a person actually chooses to fund it and administer it, just having that report created, so at least you know what that number was supposed to be, that does give them, some ammo to fire back if Medicare is denying claims in the future. So we have a few different things here to think about. One is the person can use other health insurance. So, maybe they have a spouse who's still working and, they're going to be covered under that person's insurance. That's an option for them. Really, all of this MSP compliance stuff is about not cost shifting to Medicare. So if you've got other insurance, then obviously you're not asking Medicare to pay those claims and you don't have an issue. Another option is for them to just pay out of pocket as they go. So, sometimes people will look at all this and they'll say, well, I'm going to take that money and invest it, so I'm going to have it available when I need it. and I don't really know if I want to get this surgery or that surgery, or if I'm going to need to stay on this medication. So I don't really think I need to fund the total amount that was recommended in the MSA allocation. So I'm just going to pay for what I need as I go. Okay, that's also an option. They can also set up something called a medical savings account, which is different from an MSA. So it's kind of like a health savings account combined with a high deductible Medicare Advantage plan. So it's kind of like an insurance alternative. They can also set up a settlement preservation trust, where they just keep some money available to spend on future medical costs. Now, whether or not they actually ever spend the money that way is up to them, right? So they could set up this other trust. They could, put whatever amount of money they think is reasonable in it, and then keep passing those claims through to Medicare and see what happens. So we do have, clients who have tried things like that, and I've seen it go both ways. I've seen claims denied in the future, and I've seen claims not denied. So, again, this is all about risk assessment and risk tolerance. So if a person wants to play that game and know that they've got the money in a trust later if they ever need it, that's an option for them. And then lastly, they can do something similar but through a structured settlement that is set up to pay for that future care. So lastly, we've just got some tips and techniques for you to help guide you a little bit as you're determining how you want to comply with the MSP Act. The first one is to start early. So, like we talked about earlier, at intake, you should be identifying who those Medicare beneficiaries are, again, whether they're on original Medicare or Medicare Advantage plan, and identifying the ones who, could reasonably be on Medicare in the future through their SSDI coverage, or who might turn 65 during that time. So that's something I didn't really spend a lot of time on, but, people qualify for Medicare at 65. And so if you've got a client who's 63, 64, then it's very likely that they're going to be on Medicare by the time the case resolves. Also remember, you control this process. So, there's a lot of things that we've talked about that you can do to make sure that you're complying with the MSP Act, which ties into the next one, which is to never rely on the opposing counsel's experts. Obviously they're not going to be looking out for your best interest or for your client's best interest. And so, the best thing you can do is know what all these rules are and how you're going to comply with them and how you're going to, deal with them. Also makes sense to educate your clients on what the risks are. So, I've mentioned a bunch of times that this is all about risk assessment. Every client's going to be a little bit different in terms of what their, not just, what their situation with their accident was, but also what their outlook is on the future. We've got people on one side of the spectrum who say, nobody's requiring me to do this. I'm not going to do this. I'm just going to do what I want. That's okay. As long as they have gotten the information to, to understand what the risks are, they can make that choice. And then we've got people on the other side of the spectrum who say, I never want Medicare to deny a claim. I want to make sure that I have done everything that I need to do and that this goes as smoothly as possible for the rest of my life. And that's okay too. And we've got options to do that. So in order to make all of this work, it makes sense to retain your own MSP experts, right? So if you are not personally an expert in this area, work with people who are, and they're going to be able to guide you and help you along the way. Again, go on the offensive for these issues, right? Don't leave this up to the defendant to tell you about. Don't wait for Medicare to come knocking on your door. Make sure that you are on the lookout for this. So if you are identifying those clients early on, then you know that you're going to have to deal with conditional payments and that you're going to have to talk to them about what their future medical costs are going to be. And lastly, you must document your file. I mean, that really is one of the most important things here. So whatever you decide to do or however you decide to do it, you want to be able to have that paper trail so that if it ever becomes an issue, you know what you did and you can support it. These are all the different ways that Synergy can help your firm comply with the MSP Act. I talked a little bit about the consultations earlier, but as you can see, we have a number of different areas that we can address depending on what your client's situation is. Obviously, every case is different. But again, this really addresses all sides of Medicare compliance, from addressing those conditional payments to helping your client understand the risks that they might be taking, and ultimately helps them decide what the best path forward is. And we've reached the end of the presentation. So thank you for joining us for this webinar today, and do not hesitate to reach out if we can help your firm with Medicare compliance issues in the future.